Well, welcome everyone to the Fourth Circuit Court of Appeals this morning. We've got 3 interesting cases and a group of good lawyers. And Judge Gregory and Judge Thacker and I are pleased to be with you. In the first case, Messer versus Garrison Investment Group, Ms. Tate. Good to have you, Ms. Tate. You may proceed.
Good morning. First, I want to say that it's a pleasure to be in your court. We're here today because a private equity firm in New York seeks your complicity in evading and paying employees stay pay, back pay,
and you're talking about
Garrison
Garrison? The appellee here? Is that who
Yes.
you're talking? Garrison?
That is
Garrison.
Garrison.
How are they evading? Where was liability decided as to Garrison? Where can I find that?
Liability is not decided per se at this point,
Well,
because
appellants dismissed Garrison, that's why. So who's really evading here?
well, Garrison is, but let me explain why. We non-suited Garrison, dismissed Garrison at the stage of the trial court level, where the judge had eliminated severance pay as a potential damage. And at that point, it was our goal to drop everything else and get to this court to get a ruling on
You want us to
whether-
find liability for Garrison? Because nobody has found liability yet.
Please
Well,
let me finish.
No, you've let me finish.
Yes,
I'm
ma'am.
talking.
Yes, ma'am.
I'm asking you, let me ask you 2 questions. Did you dismiss Garrison?
I did.
Was Garrison ever found to be liable?
Garrison is the only responsible person in this case.
Where
Garrison-
were they found to be? The question is, was Garrison ever found to be liable?
Garrison is both presumptively liable and liable for the judgments already of record.
Where can I find that
because-
they are liable for the judgments?
I agree with you, Your Honor, that there was no judgment from the district court.
Okay, so
But-
then what authority are you relying, and this I think will get to what you want to say.
Sure.
What authority are you relying on to hold somebody accountable for a judgment for which they were never found liable?
The Supreme Court in the Peacock case determined that the phrase otherwise liable was a way to make the defendant in the case liable. And the Supreme Court did not define otherwise liable. They used 2 phrases, otherwise liable and there's one other phrase they use, but they already liable. But they do not define in any greater structure what is liable. But here, by law, who but the owner is liable? Who but the person or entity that walked away with all the money is not liable?
And who dismissed that person from the lawsuit?
You're absolutely right. The plaintiff did. And the plaintiff did because in that suit, at that time and place, the severance plan and severance funds were not on the table and could not be obtained. We had to have this court's decision in the other Messer versus Garrison case to prove that, in fact, the severance funds, the severance plan was in effect on the day of the closing announcement, July 30, 2018. Otherwise, we were wasting money and wheels to get what we already knew the court was going to give us, and that is liability as to
And you're basing, just so I understand, and you're basing your argument on the Supreme Court case in Peacock because otherwise liable is, and according to you, not defined there, and Garrison falls into the category of otherwise liable.
Oh, absolutely. Garrison is three things here. Garrison was the sole owner of Bristol Compressors.
Why'd you dismiss them?
We dismissed them because in that court case, the law of the case was you cannot get damages by getting the severance pay. The severance pay had been taken off the table by the district judge in a very early stage. The judge determined.
But you had sued them and then you dismissed them.
Yes, sir.
And I thought you dismissed them because you had a reply brief due and you didn't have time to get it done.
I beg your pardon?
Didn't you have a reply brief or a brief due and a deadline? And rather than file the brief, you dismissed Garrison.
That's not the way it happened.
It didn't happen that way.
That's not the way it happened. We dismissed Garrison because the district court ruled that you cannot get severance pay out of this case. And that's why we needed to appeal to this court.
Wait, was that before or after you dismissed Garrison that the district court ruled that way?
Oh, the district court ruled that way when it certified the class. The class action notice had a specific sentence in it, even though we had claimed severance pay, a specific sentence in it that said severance pay cannot be an item of damages in this case. And that was Judge Jones' early opinion, and he also reiterated that opinion by giving the defendant Garrison summary judgment on the severance pay, whether it was in effect or had been terminated. And Judge Jones removed it first from the notice of class action. He removed it a second time from the case by granting summary judgment that the severance pay plan had been terminated.
Right, but by the time the court ruled on that summary judgment, hadn't you already dismissed Garrison? Because instead of responding to the summary judgment motion, didn't you dismiss him?
No, we dismissed them at a point in time where we could get to this court to get
Did you file a response to the motion for summary judgment you're talking about?
Yes. It was filed after this court's ruling that, in fact, the severance pay was in effect.
Okay, yeah. Garrison had already been dismissed from the case by the time the Fourth Circuit heard it the first time.
Right, because until we had a determination as to whether or not the severance pay had been terminated and that was no longer able.
But if you believed you were right all along as to Garrison and the severance pay, why wouldn't you have preserved that by keeping Garrison in the case?
By keeping Garrison in the case, we would have given them the leeway to drag it and drag it and drag it. We didn't want that. We wanted them out. We wanted to get a final ruling on the offenses, the violations of the WARN Act and the failure to pay the severance pay. But we
So you dismissed Garrison to expedite the case?
Yes. We discharged them.
So you wanted
because
them out for that reason, and now you want them back in?
We wanted them out because they could delay with millions of funds our getting
That's-
a decision that the severance pay plan had not been terminated, because the district court said the severance pay was terminated.
Right, but your
And-
litigation decision has consequences. They're not in the, at least from the way I read things, they're not in the case anymore, and you're trying to hold them liable when they weren't in the case when liability was determined.
They were not in that case, but the suit we have filed here, Messer 2, seeks their liability because they are the entity. They were the fiduciary of the severance pay plan.
But the
They were
Peacock
the-
case that you highlight actually says that ancillary jurisdiction does not extend, quote, over new actions in which a federal judgment creditor seeks to impose liability for a money judgment on a person not otherwise liable for the judgment. So is this a new action? Yes.
Well,
Is it a new action?
It's, yes,
Yes.
yes. It's a new action
Are
to
you a federal
collect.
judgment creditor? You
It's-
just said it's a new action to collect, so
It's
you are a
new
federal
action
judgment
To
creditor.
collect.
Are you
And-
seeking to impose liability?
I beg your pardon?
Are you seeking to impose liability on Garrison? You want them to be liable, right?
Absolutely,
Yes,
because.
okay. For a money judgment? Is that
Yes.
what, okay, yes,
Yes.
we're almost there. On a person not otherwise liable for the judgment. So that, I mean, that's exactly this case.
Um,
But that's also the language you point to for your argument. So
Respectfully,
I'm not getting it.
respectfully, Garrison was otherwise liable from day one when they bought the company. Garrison
They
was the
may have
sole
been, but
owner.
then you dismissed them. And they,
This
over their
is-
objection, which is another interesting
This
twist.
is to collect from the person truly responsible.
Which is
Garrison-
what litigation is for. I agree with that.
Garrison was the owner, the lender, and the fiduciary. They wiped out Bristol Compressors, dissolved it, and took the money back home.
And all of that
to New
may
York.
well be accurate.
I beg your pardon?
All of that may well be accurate. You might be right about everything you just said. But there wasn't a verdict rendered against them.
We didn't seek that at that time.
I know, you want to do
What-
it now.
Pardon me?
You want to do it now.
We are attempting to collect on $4 million worth of judgments entered by the district court.
Right, you're seeking to impose liability for a money judgment on a person not otherwise liable for the judgment. That's Peacock.
No, that's what Peacock says.
That is right.
Garrison is otherwise liable from day one. If not the owner, who?
No,
Who is responsible?
Right, but they have to be found
No.
liable in
No.
court.
Yes, in this case, Messer 2, the district court should find them liable for the judgments entered against their subsidiary, their instrumentality, the entity they controlled completely from day one, and we are seeking responsibility. So if you compare this case to Peacock, Garrison is TruTech, but they didn't have the evidence against TruTech. The evidence is here in Messer 1, and to be specific about jurisdiction, the defendant suggests that this is an entirely new and original case. Absolutely not. This is to do the two things: permit disposition by a single court of the claims that are in varying respects and degrees factually interdependent. All the evidence we took in Messer 1 shows Garrison is the liable person, entity. In other words, to say otherwise liable, Garrison is otherwise liable.
Which is why you should not have dismissed them from the lawsuit.
Perhaps not, but not like Peacock. In Peacock, the person who was, well, Peacock, the guy who was sued, he was not a fiduciary. He was not a controller. He was not the sole owner. And if you just look plainly at the system we have of law, and an entity does something, who's responsible? The owner or the fiduciary. And in this case, it's all three. Garrison was the fiduciary of that severance fund, and Garrison walked away, sold all the assets, and walked away with the money, and it is federally protected wages and severance pay, and this was an action. Messer 2 is an action to make the true responsible person, the person with authority, responsible for those judgments. Thank you very much.
Thank you very much, Ms. Tate. Mr. Churchill?
Yes, Your Honor. Thank you.
Good to have you with us, Mr. Churchill.
Thank you, Your Honor. It's good to be here. And let me just start with something important given counsel's discussion of the factual record below. I actually have the benefit of having litigated the case below, so I know it pretty well. Counsel states that the reason why the plaintiffs in that case didn't proceed against Garrison is because severance was taken out of the case. That's absolutely not true. As Judge Thacker stated, there were pending motions for summary judgment. The severance motion for summary judgment was pending. The motion for liability on the single employer theory of liability under WARN Act was pending. And there was an opposition brief due, which the plaintiffs did not file, to the defendant's motion for summary judgment. Instead, at that juncture, the plaintiffs sought to dismiss Garrison. Then, after the defendants opposed that motion, ultimately the plaintiffs did file an opposition to summary judgment, and Judge Jones in the case below dispensed with all of those issues in the same opinion on March 26, 2020. He ruled that he would allow the plaintiffs to take Garrison out of the case because he found that there was not sufficient prejudice. And as the court may have noted, one of the things that Judge Jones said was, I don't find sufficient prejudice, and good news, if we need to take up Garrison again, I have these motions for summary judgment ready to review and we can rule upon. Instead, he allowed Garrison to be removed from the case, and then in that same ruling, he decided that severance was out of the case.
Okay, right. So that's what I thought. So the severance pay, the decision that severance pay couldn't be an item of damage was, Garrison was out of the case at that time. It wasn't that decision was made and then Garrison.
That's correct.
Right.
The severance issue had nothing to do with the
Right.
plaintiffs wanting to get Garrison out of the case. The reason plaintiffs wanted to get Garrison out of the case is ultimately in the mind of the plaintiffs and plaintiffs' counsel. I suspected at the time that we had a full factual record on the part of Garrison that was a winner on the single employer liability case. We finished discovery in that case. We took depositions. We had briefed the DOL 5 factors, which this court has endorsed in Pennington v. Floor, and we were ready for a judgment. And so the defendants opposed.
I do have one question about
Yes,
the
Your Honor.
dismissal. The dismissal was without prejudice. Does that make any difference here to your argument or to appellant's argument?
It doesn't, Your Honor, because ultimately they didn't rename Garrison, and they could have.
They would say they're trying to do that now.
Well, and they could have at any point, which is the reason why the district court ultimately also has a ruling based on statute of limitations. Ultimately, It's not the case that this court can't hear an argument that these defendants violated the WARN Act and ERISA, but it has to be timely. So what we believe Peacock stands for is that if you have an underlying judgment and a judgment creditor, and that judgment creditor comes into court in a new case seeking to collect, you have to have a basis for federal jurisdiction. Piercing the corporate veil, which is the same remedy that was discussed in Peacock, is not a separate basis for federal jurisdiction. So we cited in our brief, well, first the district court cited a case that we cited from the Middle District of Alabama. It's called Exford v. Casey Economic Development, LLC, from 2018. And in that particular case, what happened was that there was a litigant that was arguing that, hey, this is just a collection action, and they were citing an 11th Circuit decision in Hatfield. And what the district court noted in that case was Hatfield was not a second case. Hatfield was the same case. And so you will notice that Ms. Tate has not moved under Rule 69 to execute on a money judgment. What she's done is waited until judgment was established against an empty chair, because BCI defaulted in the case below. So she had an unopposed case, got money judgments, appealed the severance decision, still didn't add Garrison back in, got $2.4 million additional dollars, didn't add Garrison back in then, and then filed this case. And so the independent basis needed for federal jurisdiction is what's missing here. So even if you assume that what the plaintiffs' appellants want to do is proceed directly now, as opposed to vicarious liability, if they want to start a new case, it would still have to be timely, and that's the reason why the statute of limitations analysis is important, and I can get to that in a moment. But let me point to two cases that the appellees cited in their brief at page 24, both from this circuit. United States ex rel Bunk v. Government Logistics, that's 842 F. 3rd 261. And in that case, similar to the decision in Exford from the Middle District of Alabama, the Fourth Circuit noted that what it was dealing with was a continuation of the original case. It wasn't a second separate case that was filed. So that would be along the lines of ancillary enforcement jurisdiction. This isn't an enforcement action at all. And then the other case that we cited from this circuit was Flame v. Freight Bulk Partnership, 807 F. 3rd 572. And that case, jurisdiction in the court was based on admiralty jurisdiction, which is a separate basis for federal jurisdiction.
Mr. Churchill?
Yes, Judge Gregory.
You would agree that Congress intended this to be a statute to protect people, particularly smaller towns, really, because sort of some places when they close, the town is shuttered too. So that was the intent of Congress to do that. And my question to you is, can you respond to Ms. Tate saying that shouldn't the owner, that's what she said, shouldn't the owner be responsible to make sure that, you know, the person who, the fiduciary, and to make sure that those monies are properly paid to people who didn't, for the warning type thing? So you're just saying your client is just not the owner at all, not responsible at all? I'm just in terms of trying to, because as a court, we, unless it's unconstitutional, we try to adjudicate that's consistent with the intent of Congress. I mean, that's what the Constitution says in a sense, unless it's unconstitutional or illegal somehow. But isn't that what we're trying to do? So would you respond to Ms. Tate's plea that's saying that, you know, like it's an old proverb that says when elephants fight, ants get, you know, trampled. So there's a fight here, but it's the people in terms of the severance employees. Can you answer that?
Yes, Your Honor. So as I indicated, Garrison Investment Group was one of two defendants initially named in the case. And Garrison Investment Group participated as a co-defendant in that case and defended itself for more than a year. and so was fully engaged on that issue. And the plaintiffs had Garrison Investment Group in the case to determine whether or not Garrison Investment Group was liable as a single employer. And what the Department of Labor standard, the reason why the Pennington court decided that that's the correct test, is what it looks at is not piercing the corporate veil standards. That's not part of the WARN Act. What it looks at is who's the employer. And there are 5 factors plus additional factors that are relevant. And so it's not a question of whether Garrison Investment Group is running away here. Garrison Investment Group defended itself. But Garrison Investment Group doesn't have an interminable statute of limitations here. So if the plaintiffs wanted to hold my clients, any of my clients, liable, they either needed to finish that first case and not drop us simply because they didn't want to fight with us, or sue on time. Instead, what happened was they sued under the WARN Act and ERISA. They sought both a WARN Act liability and ERISA damages back in a suit filed in 2018. And then they litigated the case, they appealed the severance issue, and waited until what they felt like was a favorable result. And it was my concern when I opposed the motion to dismiss. I said, I am prejudiced. My client has sat here and has litigated this case, and I don't want to be hauled into court later. The opportunity is now. And the district court said, don't worry, I've got your briefs. Well, here we are. And so it's not a case of Garrison Investment Group not being willing to face the music. It's a case of the plaintiffs not doing their job. I wanted to briefly address this question of whether or not concepts of fiduciary liability can be equated to being otherwise liable. The district court's opinion addressed that squarely.
The district court opinion, you mean Judge Jones
I do.
last year?
Yes,
2025 opinion?
correct, the one that's on appeal now. And so, yes, Your Honor. And so in dismissing the case, I believe the district court opinion addressed that directly and said fiduciary liability also is not an independent basis for federal jurisdiction. Now, if you're asserting fiduciary liability under ERISA, that can be a basis for liability, but again, you have to sue on a timely basis. So let's look at what happened. In the case below, when the issue of severance benefits was pleaded and brought before the court, Garrison Investment Group and Bristol Compressors filed a motion for summary judgment, and they said the severance plan was terminated properly. The plaintiffs opposed that motion for summary judgment and argued back in December of 2019, I believe, or maybe January of 2020. They argued this is an ERISA plan, and ERISA plans require written notice. Judge Jones took up the briefs and said, I agree, it's an ERISA plan, but termination was proper because there was a joint resolution by the board, and that's all that was necessary, and the district court considered declarations that were submitted and decided termination of severance is proper. That was in the March 26, 2020 summary judgment opinion. This court took the plaintiff's appeal up and said, we disagree. It's undisputed that it's an ERISA plan, yes. However, the termination had to include written notice to the employees, and the mere passing of a resolution was not sufficient. In fact, the benefits handbook said that there had to be a written notice from HR. It didn't happen, so the case was, the decision on severance and one other decision was vacated, sent back down to the district court. Garrison remained out of the case. This was only Bristol Compressors involved. And the plaintiffs got a judgment, the additional $2.4 million. So what we're faced with here is an argument by the appellants that somehow the clock hadn't run. And somehow it only mattered, and they only had a crystallized claim for ERISA when this court ruled that to reverse the district court. There is no support for that anywhere under the law. Just by definition, the fact that they got a judgment for ERISA damages said that they had actual knowledge of their right to claim, to make the ERISA claim. What the statute requires under 29 USC 113 subpart 2, which is the 3-year statute of limitations, which is the applicable statute of limitations here, is that you have actual knowledge of the claim. That doesn't mean that you know you're going to win. It means that you have knowledge of a claim. Did they have knowledge of a claim because they sued for one? We believe that is the case. And so if you look at the filing date of the lawsuit, the original lawsuit was October of 2018, and even accounting for tolling for COVID, because this was COVID times, and accounting for the fact that Garrison was in the case as one of the 15 defendants here, the statute has run on an ERISA claim. And the Warren Act statute of limitations is 2 years, which is provided by Virginia state law. And obviously the 2-year statute has run as well. So we believe that whether you're looking at the case from the lens of Peacock, or whether you say, okay, you've got a new lawsuit, go ahead and file now against these defendants. They're not liable for what happened to BCI, but you can sue them now. That's the second question before the court, and it's an untimely lawsuit for either of those modes of relief. And unless the court has other questions, I wanted to briefly discuss personal jurisdiction. Very briefly, the personal jurisdiction issue is irrelevant if the court affirms on dismissal for lack of subject matter jurisdiction under Rule 12b-1. But we also wanted to note that as submitted to the district court on the motion to dismiss, there is not jurisdiction over 8 of the 10 corporate defendants. They were dissolved as of the time that the lawsuit was filed, so they couldn't be liable. So even if this case were to be sent back to the district court, the only 2 proper defendants would be Garrison Investment Group and GP. And as to the individual defendants, we don't believe any of them are proper parties, but 2 specific defendants weren't even at the company. And so both of those defendants would be properly dismissed, and they are Julian Weldon and Stephen Scott Stewart. Mr. Weldon ceased being employed as of March 2015, well before any of the activity at issue in the underlying case. And Stephen Scott Stewart ceased being employed and had no affiliation as of August 2016. These are both sworn declarations submitted with the motion to dismiss. And so neither person would be a proper individual defendant. But again, we don't believe those are necessary determinations if this court affirms on Rule 12b-1. That's all I have.
Thank you very much, sir.
Thank you.
Ms. Tate?
Thank you, Your Honor. Statute of limitations of ERISA. For an individual, it's 3 years. For an entity and plan, it's 6 years. Virginia contract law is 5 years. No matter how you look at it, the statute of limitations had not run, and it accrued on April 23, 2023, when this court said that plan was not terminated, and essentially the funds are owed to these employees. Now, no execution on those judgments because Garrison had already dissolved Bristol Compressors, Inc., sold everything for what we understand is approximately $29 million. Garrison knew, as the subsidiary's parent, and actually the instrumentality of Garrison, that this court's decision gave the jurisdiction, gave the entity the authority then to sue for what we now claim. This Garrison is the fiduciary, owner, and liable, and that it equals otherwise liable. The case is timely under those circumstances because there was no point in bringing another lawsuit unless we knew that the severance plan was still in effect and it was definitely not terminated legally. with respect to jurisdiction, ancillary jurisdiction, should be given where the court can vindicate its authority, effectuate its decrees, and this court gave those judgments. This court, I'm talking about the district court, had the authority to exercise jurisdiction, and if they had discretion about it, they've abused that discretion, because this case deserves a hearing, because the owner, who else? The owner is responsible, and there has never been a denial that Garrison is not the fiduciary, and the fiduciary in Peacock did not exist. Peacock was not a fiduciary. Key difference. And with respect to the otherwise issue, the notice to the class early on in 2018 or 19 had the phrase, "No severance pay will be awarded as damages in this suit." The judge had wiped it out completely. We had to get it back on track, and that didn't happen until April 23, 2023. Hundreds of workers, millions of lost wages and severance benefits that they deserved have been wiped away. We cannot let Garrison make this playbook to guard their subsidiaries all over the country. This subsidiary and Garrison under control, Garrison with the authority to spend the money, did not pay federal owed debts to these employees. Thank you.
Thank you very much, Ms. Tate. We'll take the matter under advisement. We'll come down now and greet counsel, as is a tradition in the Fourth Circuit, and then we'll return to the bench and call the next case. In the second case this morning, Gordon versus Heath, Ms. Patterson?
Good morning, and may it please the court. My name is Sydney Patterson, and I represent the appellant, Maryland State Trooper Sergeant William Heath. In this case, the court is asked to decide whether Sergeant Heath is entitled to qualified immunity.
I think, at least for me, maybe you could speak into the microphone more or speak up.
Is this better?
A little.
Okay.
All right, sorry. Go ahead.
Thank you. The court is asked to decide in this case whether Sergeant Heath is entitled to qualified immunity as to the appellee's hostile work environment claim, which is asserted under Section 1981 in Count 5 of the amended complaint. The district court found that appellees narrowly stated a plausible claim for hostile work environment based on their allegation that their supervisor, Corporal Oros, sent a single racially offensive text to a group of task force members in their work group chat. The offensive text is the only well-pled allegation of racially discriminatory conduct in the complaint. The remaining allegations in the complaint, which asserted that appellees were excluded from certain informal meetings and group chats, are unsupported by any factual allegations. They simply state that they were excluded based on their race.
An appellant was the supervisor of this task force, correct?
Sergeant Heath and Corporal Oros are both alleged to be supervisors in the amended complaint of the task force.
What did Sergeant Heath do in his supervisory capacity in response to the text that was sent?
The allegation in the complaint is that he failed to discipline or start an investigation.
And why isn't that sufficient to state a claim at this point that he failed to do anything in response to the offensive text, which created a hostile work environment?
Well, the allegation of hostile work environment requires, for individual liability, it requires personal conduct by Sergeant Heath that was unwelcomed by the plaintiff's appellees and was based on race. The district court correctly found that there's no other allegation in the complaint that supports an inference that it was racially discriminatory other than the offensive text message, which was not sent by Sergeant Heath. And the district...
Aren't there allegations that the black officers were excluded from meetings where work assignments and overtime were discussed?
Yes, the allegation in the complaint is that they were excluded or not affirmatively invited to participate in certain meetings, informal meetings and chats based on their race, is the allegation in the complaint. And the district court correctly found that those allegations were conclusory and insufficient to support the appellee's claims for racial discrimination in counts 1, 2, and 4 of the amended.
We're talking about count 5.
Correct.
That's the only count on appeal, right?
Yes, only the hostile work environment claims,
The 1981 case.
correct, against Sergeant Heath and Corporal Oros and against the Maryland State Police under Title VII. Those are the only claims that
There's
remain.
been no discovery here.
Correct.
It's up here on the 12B6. I mean, it was the 12B6 issue.
Correct,
And the qualified immunity was denied.
yes,
So the next move would be discovery,
that's right,
if the case went forward,
that's right.
goes forward.
And as a public official, Sergeant Heath is immune from the burdens of discovery and litigation if his conduct did not violate clearly established rights of which a reasonable officer would have known. So under the facts of this case, accepting the well-pled allegations as true as we must at this stage, Sergeant Heath is entitled to qualified immunity because the appellees have failed to plausibly allege that Sergeant Heath's conduct violated their constitutional right not to be subjected to a hostile work environment.
And Judge Russell didn't buy into that.
Judge Russell said that the appellees had narrowly stated a hostile work environment claim based on the single text message sent by Corporal Oros, which was, according to the complaint, an isolated incident. And the judge noted that he was, that
An isolated incident, though, in the context of the black officers not being invited to any of the work meetings and also not being included on the text chain where all these other officers communicated about work and other things, apparently.
yes, but those allegations, there's nothing to support the allegation that they were excluded based on their race.
Counsel, you said it was isolated. It gives context to it. Those allegations that they were excluded from places, these were not just locker room discussions. It alleged that these are discussions that inure to the benefits of overtime pay and assignments. And by the time they got wind of it, all the assignments were gone. So that gives context, because you opened the door when you said it, well, this instance with the text is just isolated, but it's not on an island alone. It's surrounded by these allegations. At this point, as Judge King was saying, that's the stage we are now. So it's not, I'm just saying, it's not fair to say that's isolated. Wouldn't you agree?
Yes, I wouldn't agree.
You would not agree?
My use of the word isolated, I was referring to what Judge Russell said, that was the only time it happened in the complaint. He said it was an isolated incident. I was referring to the text message. I agree with what Your Honor said about the context. So the text message was an isolated incident. The context about the exclusion, it fails to have any facts to show that they were excluded based on race. And as the court knows, a hostile work environment requires conduct that's based on race. And an allegation that something is simply based on race without any supporting facts.
But that's where we are right now. We're in the allegation stage, and next step, as Judge King said, is discovery.
Mm-hmm. Yes. But to simply say that this was based on race is not a well-pled allegation, and this court and the lower court were not obligated to accept that as true, even at this motion to dismiss stage.
We can't look at the text here and what the text was and see that it was based on race?
The text, the racially offensive text
What
message.
was the text?
It was Corporal Oros sent a meme, a text message that was a picture of a individual.
And the individual, what's his name?
I believe his name is Berrywood. He was superimposed on a picture of George Floyd.
George Floyd, and this was during the George Floyd incident
2020.
in Minnesota.
Correct.
And George Floyd was a black man
Yes.
who'd been killed by the
Yes.
police.
Yes.
And what else did it depict?
It depicted him superimposed sitting on his face behind a Minneapolis police car. And there's no dispute.
And it depicted a lot more than that.
You're
not describing it.
The gentleman that was superimposed on him was nude and had enlarged genitals and he was nude, and he was also a black man. And there's no dispute that
You
is.
described it a little better now.
Thank you. There's no dispute that that's a racially offensive text message. However, that text
So
message.
you acknowledge that part?
Yes.
It was a racially offensive text message.
Absolutely.
Absolutely.
Do you concede that it was severe?
In the context of a hostile work environment claim, it could, for purposes of a motion to dismiss, the courts have said that there are rare instances where a single, event can be sufficiently severe to state a claim for a hostile work environment.
And that's
But
what I
the-
ask you. Do you concede that this was a severely hostile, crass type depiction. An African-American man sitting on top of someone, George Floyd's images around the country, it created an incredible amount of emotion and those kind of things, and you don't concede that was severe? And then the stereotypical with enlarged genitals, a black man nude on that?
As to Corporal Oros, yes, it could be severe, and it certainly can state a claim as to Corporal Oros, who sent the text.
So
But
you
the-
concede, you say yes to Judge Gregory's question.
As to Corporal Oros, not as to Sergeant Heath, because
And what was it again that Sergeant Heath did allegedly did in response to this severe racially offensive text message sent by someone he supervised?
to answer
He
your
did
question,
nothing.
However, there is no allegation that he supervised this individual. They're
Was he the
both,
supervisor of the task force?
the complaint alleges they are both supervisors and they both did the same things.
So why isn't a complaint that alleges somebody is a supervisor, that alleges a racially offensive and severely so text by one of the task force members, and that alleges that in response that supervisor did nothing, why isn't that sufficient to allege a hostile work environment?
Because liability under 1981 requires you to look at the officer's individual conduct, what he specifically did, and whether
Which was nothing.
And yes, there's an allegation he did not discipline, and there's allegation that generally he and Oros excluded the appellees from meetings, but those allegations are not well pled and don't support an inference that that was racially discriminatory conduct.
But I guess that's what I'm asking you. Why not? Why isn't that sufficient? Why aren't they well pled?
Because it's insufficient to simply say, based on race, we were denied opportunities.
But
or-
that's not what that's not all that the complaint alleges.
As
To
to
go
the-
back to context.
As to the exclusion, isolating to look at the conduct of Sergeant Heath, the allegation is he excluded the appellees from group texts or informal meetings based on their race. And there are no supporting facts to show that it was based on race or any other number of things. So the conduct of Sergeant Heath is limited to that, and this is a claim for a hostile work environment. To state a claim as to Sergeant Heath, they must show unwelcome conduct based on race that was committed by Sergeant Heath. This is a 1981 claim, and it requires intentional discrimination. And
You
it-
think that picture in the text was welcome conduct?
No. And in it, if Corporal
Do you think it
Oros,
was intentional to stoke racial stereotypes or to demean someone? Do you think that was intentional?
I can't speak to Corporal Oros's
No, we need
intention.
to speak to that because you're asking us to dismiss this case without any kind of discovery at a 12B6 stage. I'm asking you, do you think it was intentional, they intended to degrade, to humiliate by sending that? I'm asking you because that's what you're arguing us. Do you think that was intentional? Or
I
do you think
believe-
that was accidental, that it was nude or that the genitals were enlarged, that he was standing on George Floyd's head? Do you think that was intentional?
I believe Corporal Oros sent the text
Do
intentionally
you,
to.
so go ahead.
I
I'm
believe
sorry.
there's certainly an inference that he sent the text intentionally.
Intentionally to do what?
Well, it's an offensive text message. I can't speak to his
Intentionally
intentions.
send the text message?
He's not my client. I
To
can't,
intimidate on a basis of race?
he was certainly being racially insensitive and offensive in sending that text.
It was hostile?
But he is not my client, and he is not here asserting qualified immunity.
But you're the one who are answering our questions. That's what
Right.
you're the one you want to throw the case out. without discovery, you want to win. And Judge Russell wouldn't let you win, and so you came up here. And so now you're going to have to tell us why you need to win.
I'm not asking you to throw the entire case out, just the case against Sergeant Heath.
You're only here on count 5, 1981. And you say it's a hostile work environment claim. So you have to prove to us, or establish to us, or convince us that it doesn't measure up as that kind of a claim. And that your client is entitled to qualified immunity in these circumstances, as alleged and taken in the light most favorable to the other side.
Yes.
Have I misstated any of the legal principles?
No, Your Honor, but the analysis.
So you got an uphill battle with this appeal. Do you recognize that? When you're coming up here appealing a situation like this, and this text is, you admit it's hostile. You admit it's racially based.
Yes, but Sergeant Heath did not send it, and there's no allegation he
And
participated.
you're saying your client didn't send it. He didn't do anything about it, and he was the boss man.
That's also not alleged in the complaint. The allegation is that he and Oros were equals, they were supervisors.
What's the word supervisor mean? He was the task force supervisor.
Correct, and supervisory liability under these statutes looks at the
I take
acts of a
supervisor to
subordinate.
mean the boss. Maybe I'm old-fashioned.
I see that my time is up, so.
And you'll say some rebuttal time,
Right.
and I've taken some of your time too, but anyway.
Thank you.
Thank you very much for your work. Mr. Spicer,
Good morning, Your Honor.
good to have you with us, Mr. Spicer.
It's nice to be here. May it please the court, Ms. Patterson spent a lot of time talking about the text message, but this text message did not occur in a vacuum. Plaintiff's amended complaint, from plaintiff's perspective, appellee's perspective, is that it was a well-pled complaint. It is not a bare bones complaint. Within the four corners of the document, the complaint establishes that Sergeant Heath was not a peripheral actor. He was the boss. He was the supervisor of Don Gordon and Terrell Jones, who were his subordinates and who are African-American task force members. The complaint establishes that Sergeant Heath was their supervisors, that he oversaw their day-to-day operations, that he controlled their work schedules. He controls when they worked, how they worked, the kind of work they did. Furthermore, the complaint...
Is there any allegation that he controlled Oros, or were they even?
They weren't even, Your Honor, because he's a sergeant and Oros is a corporal.
And that's alleged in the complaint.
And that is
correct?
alleged in the complaint as well.
Sergeant Heath outranked
Correct.
the corporal.
Correct. He outranked Corporal Oros, and that Sergeant Heath had meetings. He held those meetings. They were informal meetings. Similarly situated, white task force officers attended those meetings. Sergeant Heath also had, as alleged in the complaint, text message threads that invited white task force members. They were similarly situated in every which way, same task force, same supervisors, same overall types of duties. But in those informal meetings and in those text message threads, that's where the better jobs were being divvied out or provided.
And those text messages omitted your client's name?
Correct. They were omitted. It's alleged in the complaint. They were excluded.
Right, so opposing counsel argued that there aren't any supporting facts to show that this was based on race, but it sounds like all of these things that you're talking about now that were alleged in the complaint are the supporting facts, at least at this stage, to show that it was based on race. Is that correct?
Yes, Your Honor. It was, all of this occurred before the text message thread. So it's a pattern of conduct. As I was saying before, the text message thread did not occur in a vacuum. Sergeant Heath had those meetings, as did Corporal Oros, had the informal meetings, had the text message threads that did not include Gordon and Jones before this incident of June 2nd, 2020, when Corporal Oros sent the racially insensitive text message. So Gordon and Jones went through all this, the exclusion from the informal meetings, the exclusion from the text message threads, seeing that the white task force officers, similarly situated as them, same task force, same types of duties and responsibilities, same supervisors, they were getting the overtime, they were getting the better investigations. Meanwhile, they were just sitting there watching. Furthermore, as alleged in the complaint, Gordon and Jones rarely had any communications with both Heath or Oros. That's alleged in the complaint as well. Rarely communicated. So, Your Honor, before June 2nd, 2020, all of this occurred. And then additionally, on June 2nd, 2020, this text message thread comes out. So, in the light most favorable to the plaintiff,
When was
Pelleas.
the George Floyd incident in Minnesota?
I can't remember, Your Honor, but it was 2020. So it was not long. It was not long after the Floyd incident that this text message came out, and that's why it hit hard during this time period. So it was a pattern of conduct. It's not just one.
Well, it would hit hard during any time period.
Yes.
Particularly so at that time period.
Absolutely, absolutely. So it was a pattern of racial discrimination alleged in plaintiff's complaint, and the text message thread just put a cap on that. And
But I get, opposing counsel argues that since count 5 is the only count left as to her client, and that's the hostile work environment claim, with that we should only be looking at the text alone without, that's the way I heard her argument. That might not be what she meant, but without all of this other context, and that the district court sort of blessed that view. What's your response?
Your Honor, that is not how I see that the district court saw the complaint and sees count 5 as the only substantial piece of evidence related to count 5. The court looks at the 4 corners of the complaint. That is what they do. And that is how this court will look at it as well. They look at the 4 corners of the amended complaint and then make a determination in terms of whether all the elements are met with respect to Section 1981 in the hostile work environment claim. If the court would like for me to go through the elements, I can go through the elements of a hostile work environment. Clearly, the conduct of Sergeant Heath in excluding Gordon and Jones from...
It's not a Title VII case.
Correct. It is not a Title
It's
VII.
a
It's 1981.
case.
That is correct.
1981 comes from the Civil Rights Act of 1866.
Yes, yes. So, and it also has an employment element in terms of discrimination with respect to contracts. The courts have found that with respect to 1981, employment is a contractual basis and is included in 42 U.S.C. 1981. So, and with respect to 42 U.S.C. 1981, Gordon and Jones are a member of a protected class in that they are African Americans. And so with respect to 42 U.S.C. 1981, I can go through that as well. Bear with me for 1 second, Your Honor. So in terms of the elements of 1981, Gordon and Jones are African Americans and are members of a racial minority and are members of a protected class with respect to 1981. In terms of showing that there was intentional discrimination, in looking at the complaint, we see a pattern of racial discrimination and racial exclusion from Sergeant Heath, in that he intentionally excluded them. He could have invited them to the meetings that he held, the informal meetings that he held. He could have invited them into the text message chain. He could have included them in his decisions to hand out assignments in terms of handing out overtime claim or overtime work. He chose not to do that. And with respect to the text message of June 2nd, 2020, I think it also provides more evidence of his intention to discriminate against Gordon and Jones, in that he did nothing with respect to a clearly racial discriminatory, racial insensitive text that was sent out by Corporal Oros. He did nothing. He did zero. And it didn't, and it can be argued that as a result of the pattern of conduct, the reason Oros decided to send out this racially insensitive text message is because of what went on before. That he felt that he could. That he felt that nothing would be done.
And he was right.
And he was right. So there is intentional discrimination with respect to the second element of Section 1981. And with respect to the third element, the discrimination concerned one or more rights protected by this section. And one of them, as I mentioned, is employment. The enforcement of contracts also includes employment. And clearly, there's a pattern of racial discrimination and racial exclusion with respect to the conduct of Sergeant Heath. And it was a pattern, not a one-time thing, as Sergeant Heath claims. And that injury was suffered as the last element as a result of this. It created a racially tense, racially divisive environment for Gordon and Jones, and it also affected their employment. They were not provided the jobs, the investigations, the overtime to make the compensation that other similarly situated white officers were allowed to. Now, if this case is allowed to go forward, plaintiff would be seeking discovery along these lines. But at this stage, Your Honors, in the light most favorable to the plaintiff, based on the four corners of the document, the amended complaint, plaintiff has pled a well-pleaded complaint and has established all of the Section 1981, all the elements required to establish a 1981 claim, and also have established and met all the elements required to meet or to establish a hostile work environment at this stage of the litigation. And at this point, if the court has any questions, I'll be more than happy to answer them. I can go into, since we're talking about qualified immunity, I can go into the rights that were violated in terms of the first prong of qualified immunity. I can also go into that law was clearly established with respect to qualified immunity, in that I think it's pretty clear when we're dealing with racial discrimination claims such as this, that we're not looking at a police officer. We're looking at Heath as a government official. That is what he is. And qualified immunity applies to government officials. And with respect to a government official, I think the law is pretty clear in terms of first, the rights, the statutory and constitutional rights that were violated by Heath with respect to Gordon and Jones. When we're looking at the 14th Amendment Equal Protection Clause, we're looking at case law in which state actors, such as government officials, violate laws, especially with respect to racial discrimination. There's a long line of cases that deal with that. You can go back to Strouder versus West Virginia. You can go to Loving versus Virginia. Granted, they don't deal with text messages, but they deal with Equal Protection Clause claims in which government officials, state actors, violate individuals' rights with respect to racial discrimination claims. And there are many others. And with respect to the second prong, clearly established law, racial discrimination claims and with respect to government actors, it is just so obvious that Heath was put on notice that racial discrimination is wrong and that there are constitutional and statutory provisions in place, well established, decades ago, that it is wrong for a government official to violate someone's constitutional rights by racially excluding them and racially discriminating against them. Again, Equal Protection Clause of the 14th Amendment deals with the states. Equal Protection Clause of the 5th Amendment deals with the federal government. We're talking about Title VII. Even though this isn't a Title VII claim, this would have or should have put Sergeant Heath on notice that it is wrong to racially exclude individuals and racially discriminate against them. Any reasonable officer, any reasonable government official would have or should have known that. And the law on this issue is beyond debate. It is not something that can be debated. That it is wrong. It's a statutory violation and a constitutional violation to discriminate against someone based on their race. And as this court knows, you don't need to find a case on point. There doesn't have to be a case on all fours with respect to this particular case. In this case, it is obvious. It is obvious. The law is clear with respect to racial discrimination cases that a government official, a state actor, is not permitted to racially discriminate against a subordinate employee. And with everything that I've just said, Your Honors, in the light most favorable to the plaintiff at this stage, based on the four corners of the complaint, Don Gordon and Terrell Jones are asking you to deny Sergeant Heath's appeal based on qualified immunity. I will end there unless the court has any questions.
Thank you very much, Mr. Spicer.
Thank you very much.
Good to have you with us.
Nice to be here.
Ms. Patterson?
Thank you. Your Honors, in this case, this hostile work environment claim is asserted against the employer, the Maryland State Police, and 2 supervisors, Sergeant Heath and Corporal Oros. In determining whether qualified immunity applies, the court has to look at whether the allegations in the complaint establish that Sergeant Heath, through his own individual actions, violated the constitutional rights of the plaintiffs. And the only allegations of conduct by Sergeant Heath are not based on race. They allege he was one of the supervisors who excluded the appellees from meetings. And simply to say that it was based on race is not sufficient. There has to be an allegation of fact to show discriminatory intent and purpose by Sergeant Heath.
Like what? Like Heath says, let's exclude them because they're black?
Well,
Why isn't it enough to allege that they were excluded from the meetings with the white officers and they are black? The people that were excluded were black. We cannot make an inference that that was based on race at this stage?
when there's no direct evidence, the law requires that.
Well, there's no evidence
be-
at all in this case.
Correct.
We've got a complaint. We got a complaint.
Yes.
Does the complaint allege enough? That's the question.
Right. So in this instance, the plaintiffs have to
They want to
demonstrate.
get to the evidence. That would happen if we don't recognize your claim of qualified immunity, and the case goes forward, like any other case in the court system.
At the pleading stage to show.
And then you'll have discovery, and you'll have summary judgment motions and things like a lot of other motions. And then the court will get to decide whether there's enough evidence to go to trial. And if the court lets it go to trial, then you have a jury. And either one of you might win. And then the loser at the jury trial can appeal it up here. And we can take another look at it. We're at the very beginning of this piece of litigation. And we have to look at it in the light most favorable to the other side, from you. And look at this complaint and what it says.
Mm-hmm.
And take what it says as being true. The allegations are true. Take it as true for purposes of this.
But only the well-pled allegations need to be taken as true. And the racial discrimination claims were dismissed and rejected by Judge
Well,
Russell.
you've explained, you've told us what that text was all about. I mean, that's blows us away almost.
But Sergeant Heath is entitled to qualified immunity unless his conduct violated the constitutional rights. There is no factual assertion such as a demonstration of similarly situated employees, which is typically how one pleads racial discrimination. Judge Russell noted that they simply state that similarly situated employees were included in the meetings without any facts to demonstrate that. And those are the type of conclusory statements that do not have to be taken as
Counsel,
true.
you disagree about the emails that excluded them? At this point, are you disputing that?
I dispute that the allegations in the complaint are
No, I'm not. You go to the macro when the question is silly, micro. Do you dispute that their names were left off the email tree to come to the meeting to discuss things, including overtime? You dispute that as a fact?
At this stage, we have to take that allegation as true.
Okay, then, all right.
But
you say they don't properly allege facts. That's what you said.
because there's no constitutional right to be included in meetings. The constitutional right at issue is not to be racially discriminated against.
Okay, Counsel, may I ask you a question? This is clearly hypothetical. Suppose a female is working in a crew of 10 people, and this is hypothetical, it's not this case. This is not counterfactual, this is hypothetical. And all of the meetings are in the men's bathroom where they divvy out overtime assignments. And all that she could plead was, I never get to go to the meetings because they're in the men's bathroom. That wouldn't be sufficient, would it?
That is a great example of the type of factual assertions that can support a claim
That's
of
fine, isn't it?
discrimination.
That's fine, isn't it?
Because it's
No, wait a minute,
specific.
wait. You said my hypothetical was okay, right?
Yes, those
But
are
is it-
facts.
Okay, so, because you concede that, isn't the men's bathroom the counterpart to this real case of the invite? You can't go to the meeting that you're not invited to, just like she couldn't go to the meeting because she's a woman in the bathroom. It's the same parallel difference, isn't it?
Well,
In terms of what he could plead.
holding it in the men's bathroom supports an inference that women are excluded. But in this case, there's no facts like that. They're just
Well,
simply...
not inviting black people doesn't do the same thing?
That's not what the complaint says, Your Honor. The complaint says they were not included, and the meetings included white
were not
members.
And doesn't it also say that they're black?
It doesn't say that that the meetings didn't include any black members. It just says it didn't include them. It also doesn't say that it included all task force members. It's a subtle, I think there must be a reason it was pled that way, but there are no facts to support. Like, for example, if the complaint did allege no black task force members were included in this, but this complaint, it's a fine point, but it specifically alleges we weren't included in meetings that included white task force members. It doesn't say all the white members. It doesn't say and none of the black members. There are no facts, and simply stating based on race, it doesn't allow you to get past a 12b6 motion because there have to be factual allegations, or else anybody could just add that into a complaint. And there's no constitutional right to be included in everything, but there is a constitutional right to not be racially discriminated against or discriminated against based on your gender or disabilities. And those require a showing that that is in fact what motivated the exclusion. And here, we don't have that, and that's exactly why Judge Russell said that the race discrimination claims have to be dismissed.
Judge Russell said what?
That the racial discrimination claims would not go forward, and he dismissed them for failure to state a claim.
And those aren't before us. This is the count 5, 1981.
Right.
One count.
And Sergeant Heath's conduct, as alleged in the complaint, the well-pled allegations are that he excluded these 2 task force members from meetings and some group texts, and that's it. There's no allegation that he sent a racially offensive text message. There's no allegation.
And that he failed to do anything in response to the racially offensive text message.
Correct. And that would still require a showing that his purpose and intent,
You know what that red light means?
yes, it's been on for a long
I'm-
time.
It means that your time's up, and we've given you extra time. And if you've got another sentence you want to relate, sum it up, you can do that.
I believe I've lost my train of thought, but I appreciate your indulgence in allowing me to go over my time.
Thank you for your work. And Mr. Spicer, we thank you. We'll take the case under advisement. And we will also at this time come down and greet counsel. And we'll take a brief break after that, and then we'll come back and hear our last case. You may be seated. And in our last case of the day, Devarte Malgar versus Bondi. Mr. Annan, good to have you with us, sir.
Yes, good morning, Your Honor. May it please the court, this case presents two narrow issues, Your Honor. First, whether the board misapplied its own decision in matter of Fernandez when it treated petitioner's defective NTA objection as waived. And second, Your Honor, whether the agency's adverse credibility and persecution analysis requires remand under this court's precedents. I'll begin with the NTA issue because the timeline of the governing law is critical. Congress defined NTA in 8 U.S.C. 1229A1. The statute required the charging document include, amongst other things, time and place of the removal hearing. In this case, the NTA served in April 2016 did not contain that information. Instead, the date and time were provided through later separate hearing notices. At the time of petitioner's immigration proceedings, controlling precedent was the board's decision in matter of Bermudez Cota. Bermudez Cota interpreted Pereira narrowly and held that a defective NTA could still be sufficient when followed by a later hearing notice. So when the individual hearing occurred in November 2019, the governing BI precedent treated two-step notice process as acceptable. That legal framework changed when Supreme Court decided in Chavez v. Garland in 2021 and held that a valid notice to appear must be a single document containing all the information specified in the statute, including hearing date, time, and place. Court.
And why is it that you say that your argument on this was not waived?
Your Honor, in 2016, when the pleading happened, the general knowledge of the significance of.
So because the case law, the Fourth Circuit case, specifically Cortez and others, that forecloses the argument you're making now didn't occur until after 2016?
That is correct, Your Honor. And not just that, the significance.
When did you raise the issue?
At the BIA level in 2021, just after Ms. Chavez. Just after Ms. Chavez.
So the IJ didn't deal with this at
Your
all?
Honor, because the two-step
That
process.
sort of upends the normal way appeals are handled. Appeals normally deal with issues that the trial judge, here the IJ, dealt with. And here, issue was not raised with the IJ, it was raised with the Board of Appeals, Board of Immigration Appeals, the BIA we call it.
Correct, Your
So
Honor.
you got to get around the waiver issue. You recognize that, don't you? That's an uphill battle.
The timing, Your Honor, yes. The legal community, Your Honor, at the time, 2016, up until 2021, did not recognize the relevance and the significance of just not having the time and date. Even today, if I object to the time and date, the IJ will decide as the case dismissed or terminated for failure to prosecute. the charging document was not complete, was not available according to Ms. Chavez. The charging document was unavailable. The entire proceedings happened without the charges, without the charging document. And the relevance of just not having date and time was provided in Ms. Chavez for the first time. And after that, at the first meaningful opportunity to raise that objection, the petitioner raised it in 2021. It's like saying, I did not have the right to even waive before 2021. Even matter of Fernandez, Your Honor, came in 2022 after we raised it at the BI level for the first time, after the briefing was done. So before all this, the governing BIA president treated two-step as acceptable. And after that, now, the judges do not allow it to move beyond that first hearing if you object. Because now understanding and the significance is already there in the community as a whole.
But isn't the law that this is not jurisdictional anyway? It's a claim processing point.
Correct, Your Honor. And that is why we are not asking, we are not disputing jurisdiction, we are disputing the timing was correct. Because if we see it from this perspective, that when this case has, this particular issue has evolved through years, like what is an NTA, a charging document? And what can you object? Earlier, when we used to object to this particular matter, the judges used to ask us to brief on the matter. Okay, send me a brief. Now they do not. Now they dismiss, say, failure to prosecute. It has evolved, this particular subject matter has evolved through the years. Now we are talking in 2016. Nobody knew about it. The waiver must be, BI stated, you did not raise it at the IG level, it's waived. The waiver must be knowing and voluntary. It was not known, not just to petitioner, but to entire community as a whole. We didn't know the relevance of not having a date and time at the NTA. It's like the analogy we can take, nobody, no crime. Nobody, unless you find the body, you cannot be charged with murder. Something like that. That the analogy part, Your Honor. So that framework changed after Ms. Chavez. And Ms. Chavez says one single document, not two, one, has to have all of it. And then the timing, after Ms. Chavez was decided, petitioner filed BIA merits brief in August 2021, raised a defective NTA argument. Importantly, that brief was filed, Ms. Chavez had already been decided, but the board had not yet issued matter of Fernandez, which later articulated the agency's procedural rule regarding the timing of NTA, Your Honor. Importantly, the statute itself does not specify such objection must be raised and
So
when.
you're saying the waiver could not be valid because it was not a knowing waiver, because the community, the legal community was not aware of the significance at the time. Is that what you're saying?
Up until 2021.
And then where does that leave us, since, as Judge King pointed out, that's a claims processing rule versus jurisdiction?
Your Honor, if you ask me, I will say, according to Ms. Chavez, it's a jurisdictional issue. There is no charging. Ms. Chavez says.
But that's not the
Wait,
law.
that's not, yeah.
You can say that you'd like for it to be that way, but that's not the law. It's a claim processing point, claim processing rule. I think is what matter of Fernandez says.
A matter of Fernandez talks about agency's procedural way of handling this. Statute does say,
And we got a recent case, Hernandez, not Fernandez, Hernandez, from 2025, says same thing.
correct, Your Honor, that is why our entire case is based on the timing of how the law has evolved during the years, and when our issue was raised in the system. So that's why there's.
Okay, you raised it. All right, we'll give, I think what Judge Thacker mentioned, or we'll give you credit for raising it, but it still loses because it's a claim processing point. It's not jurisdictional. So we don't throw the case out for lack of jurisdiction. If it's lack of jurisdiction, maybe we'd have to throw it out, but it's not a jurisdictional point. You're arguing something about claim processing. I mean, you could argue that you're prejudiced by some delay, maybe that this caused the delay. But how long was it? The notice to appear didn't have the date and time on it.
2016.
And,
Your Honor.
and when was the date and time provided? A few days later?
Somewhere in the so what happened after the pleading happened, so before the pleading, they must have provided the court hearing date. But Your Honor,
You don't know when they got
exactly when.
You don't know when you got the date and time.
Before the pleading, Your Honor. They must have sent us.
Well, I bet that lawyer for the government will tell us here who that is.
But Your Honor, in the matter of Fernandez also, they say generally must be raised, generally. That means there must be an exception. It's a general default rule, yes, but not always you have to. Generally, yes, you have to raise that there, but not always. So in this case, board treated petitioner's objection as categorically waived under Fernandez, but the petitioner raised the issue during the administrative appeal after the Supreme Court clarification and all that stuff. The board never meaningfully analyzed whether the timing fits within the Fernandez framework. Happened after 2022, later even. Fernandez came later. Second, Your Honor, even apart from the NTA issue, the remand is warranted on the merits. IJ denied relief based on adverse credibility, and in the alternative found the petitioner had not shown harm rising to the level of persecution. Stated, has to be a physical harm. And this court has already decided that it's the physical injury is not necessary considering the severity of the threats and extortion what the petitioner faced in this case, Your Honor. Legal error matters because petitioner's case is built on repeated threats tied to her political activism, threats to her daughter, and extortion accompanied by a threat to cut out her throat or tongue. You know, the credibility issue was also there. As the judge said, they were not credible. The agency failed to engage fairly with petitioner's explanation that the later caller referenced prior arena threats, which is why she understood the threat as connected. That was overlap, not mutually exclusive. The overlap explanation was in the record, but the agency treated it as speculation rather than grappling with it. Petitioner's case is not random extortion only. It is a political activity with threats, then a later extortion threat that referenced the earlier political threats. The agency treated those as mutually exclusive rather than potentially connected. The agency focused on whether there was one call, two calls, But the core event remained the same. Throughout the record, petitioner received threatening calls demanding money, threatening to cut her tongue. Differences related to how the earlier political threat and later extortion call were described, not whether the threatening conduct occurred. The credibility issue also talked about sources of threat. Petitioner said arena supporter threatened her politically. Later, the phone call came from someone identifying as MS-13. The IJ treated this as inconsistency, but the petitioner explanation was that the caller referenced the earlier political threats, which is why she understood the event as connected. The agency treated that explanation as speculation instead of evaluating it within the broader context of political violence and gang activity. Also talked about number of threats, how many times they came. The differences between the initial credible fear interview and the later testimony are not unusual. When someone travels days, weeks, months, and suffer what they have suffered during the journey to reach the US, they are under trauma. They always say things, and then once they are here, they calm down, they talk to the lawyers, and their mind starts working. They recall things that they missed at the credible fear interview at the border. Family affidavits, differences there as well, Your Honor, because the differences reflect.
So you're explaining why people get the facts mixed up.
Yes, Your Honor. At the border,
They tell different stories. When
they don't
first
tell different stories. They
come-
miss some things. They don't tell.
When they're first interviewed, they tell one story, and later on, they
They do not. They don't say different stories. They just may miss. MS-13 called. Arena guys called. How many times? They may say, "Oh, one time only,"
their
and then
memory is refreshed.
the memories is there, but the thing is, trauma is also there. Trauma, because the journey to the U.S. is not a very nice journey. They go through a lot of things, maybe raped, threatened, abducted, a lot of things, Your Honor. So, unless the court has questions, thank you.
You save some time for rebuttal. You have some rebuttal time.
Yes, Your Honor. Thank you.
Thank you very much.
Thank you.
Ms. Lee, you're on the video over here for us.
Good morning, Your
Representing
Honors.
the Attorney General. Yes.
Good morning, Your Honors. May it please the court. My name is Sana Lee, and I'm representing the Attorney General in this case. Your Honors, the first issue in the case concerns the objection to the NTA and the fact that the petitioner did not timely raise that objection. And as you have already discussed, the court has already ruled that this is not a jurisdictional issue. And the board has held that this is a claims processing issue. And so in Matter and Fernandez, the petitioner was required to raise the objection to the NTA prior to the closing of proceedings before the immigration judge. And in this case, the objection was raised in the appeal. So it was not raised before the immigration judge at all. And the petitioner had an attorney at that stage before the immigration judge. And there was no mention of anything about the NTA, nothing whatsoever. And the petitioner just went ahead and pleaded to the NTA at that stage. And then the immigration judge went on to the substantive matters regarding the asylum application. And to answer
How
a
can one of
question.
these claims ever be valid? Do you think they can't?
No, Your Honor. as the board held in Fernandez, the petitioner could have raised it before the immigration judge.
I understand,
And-
I understand, and that they're supposed to raise it before the immigration judge, and they didn't. They did raise it before the BIA, and you say, well, but it's a claims processing rule, it's not a jurisdictional rule. So can a claimant ever get, or an applicant ever get relief based on the insufficient notice to appear? The answer, I think, of the Attorney General is no.
Not in this case, not with the timing of the objection. No,
You
Your
could
Honor.
never, in any case, that could not get any relief. I mean, it's an error, but you can never get relief from a failure to give a sufficient notice to appear. Is that,
Well,
is that the
yeah.
government's position?
Well, you could get relief if you raise it at the right time. You could
What
raise
what
that.
would your relief be? To you get a new notice to appear.
Yes, Your Honor. You would not be able to terminate your proceedings.
Right, you just get the blanks filled in.
Right, Your
I
Honor.
mean, the notice to appear is insufficient because, for place and date, correct? So if once you get the place and date, it's sufficient. That's what I can't, seems to me, that the government, the Attorney General's position is, a
Yes,
claimant
Your Honor.
can never get any relief on this kind of a claim.
Well, Your Honor, as you know, we've gone over the fact that this is not jurisdictional.
It's
So
not jurisdictional, it's a claim processing rule. And
yes.
once it's raised, you tell them, you have to be there, or you were supposed to be there this date and this time, and they're supposed to comply with it, and you go forward with the proceeding.
That's correct, Your
And
Honor.
try to raise it in the Court of Appeals, and you tell us, well, it's not a jurisdictional thing, it's a claim processing rule, and it was basically a harmless error. We deal with that a lot, not in criminal cases, we know something about that. So it's like a harmless error. But it's in this situation, seems to me, the Attorney General's position is that this kind of a claim is always harmless error.
Well, Your Honor, I can't speak for every circumstance or situation that may not have been addressed by the board, but I would say under the facts of this case, yes, he raised it too late, so he cannot get relief. I'm sorry, the petitioner
Well, you couldn't
could
get
not.
relief anyway, all you get is a date and time, a place and date. You get a hearing
Yes.
date, you get notice
Right.
of when you're supposed to show up for the hearing.
Yes, Your Honor, and this petitioner did show up
it's-
for all of her
So it's
hearings.
not much of an issue, except that the government needs to fix it and do a better job and not pass out these notices to appear with blanks on them, or blanks that are unfilled.
Right, Your
You
Honor.
need to put in the place and date that they're to show up.
Yes, and I believe that the DHS has begun to ensure that those that information is included in all NTAs. But at the time of this case, this petitioner's particular case, it did not have the date and time, but it was probably a few days later, it was May 12th, 2016, that the immigration court provided a notice of hearing to the petitioner, which provided the date and the time
How
of
much
her next.
of a delay was it?
Well,
Our lawyer doesn't know, and
May,
I said that you would know. And what was the delay between giving them the notice to appear that was insufficient and completing it? A few days, you said.
it was, yes, 2 days.
Can you count? The day,
Two-
tell us how much of a delay was it?
2 days, Your Honor.
2 days. Now we got an
Yes.
answer. 2 days. And a
Yes.
2-day delay, and that's what we've been talking about here this morning, a 2-day delay for the date and time. Okay?
Yes.
And then there's,
Right.
then they got another issue about the merits of this thing.
Yes, Your Honor. So moving on to the adverse credibility determination. The merits involves the agency's determination that she did not warrant asylum or withholding of removal because her testimony was inconsistent with so many other things, including the credible fear interview and her asylum application, and then later her affidavit that she prepared a few years after she submitted her asylum application. So in this case, the petitioner's story did change, and it morphed from fearing gangs and extortion. And I believe she thought it was because she was part of a female household that the gangs were targeting her for extortion. So that's what she told the asylum officer in the credible fear interview. And then it started to change. In her asylum application, she still was relying on this fear of gang story, fear of extortion. And in the asylum application, she continued that theory. But then a few years later, she filed her affidavit, which was the first time she mentioned that she feared the arena party, and that she feared the arena party based on her own political opinion. So that was the very first time she mentioned that. And then in her testimony, she expanded that theory, which was that she feared the gangs and the arena party, and that it was the arena party that threatened to cut off her tongue. So that was a clear inconsistency with her original claim before the asylum officer, which was that the gang member threatened to cut off her tongue. And so these are clearly different stories, and the agency pointed out all the inconsistencies which are located in the record. And
How many inconsistent stories did she give?
I'm sorry?
How many inconsistent stories?
Well, Your Honor, there are so many inconsistencies. I'm not sure exactly how many there were, but there were inconsistencies about who threatened her. So that was really an important, significant inconsistency, and why they threatened her. So that's very significant as well. So at the beginning, she didn't claim to fear any harm based on her political opinion. And she said she never got any threats based on her political opinion. But then in immigration court, she testified, well, I fear persecution, and I was threatened based on my political opinion. So those are very clear inconsistencies. And then there were also the number of threats that she says she received. So it began with one threat at the very beginning, and then she changed, and by the time she testified before the immigration judge, it was 4 different threats, as well as two of them coming from the arena party, and that's what she testified to, based on her work for the FMLN party. And So there were the number of threats, there was also the timing of the threats. At the beginning, before the asylum officer, she claimed that she received a threat a week before she left the country. And then later on, she testified it was a few months before she left her country. And so there were numerous inconsistencies regarding who, why, and how many times, and what they said to her. And regarding her
Was there
explanation,
only- Did she only testify once before the IJ?
yes, Your Honor.
Well, and that's, so only in one of the statements was she under oath.
Well, I believe before the
You say
asylum,
she made multiple statements that were inconsistent, but only one of the statements she ever made was under oath, and that was before the IJ. Correct?
well, I believe that when you answer questions to an asylum officer, you do, there may be an oath there, although I would have to,
The asylum officer swears them in before they ask them questions?
well, Your Honor, I can't say that for sure, but,
I don't think I'd heard that before.
okay.
But that we know she was under oath before the IJ. Well, why
Yes, we
wouldn't you just-
know that,
I'm sorry.
Go ahead.
yes.
No, you
Counsel, didn't you say she submitted an affidavit?
Yes, Your
That
Honor.
was under oath, wasn't it? That's what an affidavit is, isn't it?
Well, yes, Your Honor, I believe that she,
Well, you don't
had
think
it
it is, is it? I'm just
notified.
asking, isn't the affidavit under oath?
Yes, Your Honor, I'm sorry, she had it notarized, yes.
Yeah.
So that was under oath as well.
So there's at least two of her statements are under oath, the IJ testimony and the affidavit.
Yes, Your Honor.
Okay. Now, those inconsistencies, when she's under oath, would you agree with me, would be more material than statements that were made offhand in interviews, perhaps? Not under oath.
Well, Your Honor, I believe that all of the statements are important, and the most important factor is that the agency may rely on those earlier statements, even if
I'm
they,
not talking about whether they relied on them or not, but you don't know whether they were under oath or not. People are under oath, they're sworn to tell the truth. And then when they're not under oath, they aren't sworn to tell the truth. If the oath means anything, they're more likely to tell the truth when they're under oath. That's the premise of the whole thing. And that's the way, and our system operates that way. Now, they shouldn't be telling the truth all the time, but I just was trying to figure out how many of you said she made a lot of statements and there were a lot of inconsistencies. How many of them were under oath and how many weren't, but you don't really know. Except there were two now we know were under oath.
yes, Your Honor. So, despite the fact that she explained after the fact that she did not remember to add certain information to her asylum application. She said she just didn't remember to add information about the arena party and her fear of that party.
And that's a legitimate answer, to not remember, as a general proposition. People forget things.
Yes, Your Honor. People do forget things, but that doesn't mean that the agency was required to give credit to that explanation. The agency can reject an explanation, under this court's law, and the substantial evidence in this case is there to support this adverse credibility determination. And as far as opposing counsel's explanation today that she was suffering from trauma and the journey to the U.S., she didn't raise those explanations to the agency. So that's like an after the fact explanation, which she attempted to do before the board as well, saying, well, they're all the same thing in my mind, that the MS-13 gang and then the arena party members, they're all kind of morphed together in my mind, but that's not what she said before the immigration judge when she was testifying. When she testified, she said, well, I just didn't remember to bring these things up in my asylum application. And so, Your Honors, the adverse credibility determination was clearly supported by substantial evidence, and it was dispositive of her asylum and withholding applications. And if Your Honors have nothing further, the government will rest.
Thank you very much, Ms. Lee. We appreciate it.
Thank you.
Mr. Anand, you've saved some time.
Thank you, Your Honor. There's some inconsistency here as well, Your Honor, with respect to opposing counsel's statement regarding what will happen if there is no date and time today. What will happen is nobody will go forward. The judge will terminate the proceedings, and unless you send us one document has date and time, all the allegations.
Right, that's what Judge King said, that they'll get a new date and time, right?
If they do not rectify, it will be terminated. So it will be terminated. That is what will happen, even today. There is, and also Fernandez talks about an objection of non-compliance of NTA.
Wait, what do you mean it will be terminated? Then there
It will
won't be any more immigration proceedings, that's it?
We
Petition
have a
wins?
lot of cases terminated, failure to prosecute, then for 4 years we don't hear anything, and all of a sudden we get a new NTA, and then we read it.
Okay, you get a new NTA. Okay,
we
that's
really-
the part you're leaving out, and that's what Judge King said would happen. I'm not sure that's your best argument, but
Your Honor,
you go ahead.
Fernandez says, the objection to a non-compliance NTA will generally be considered timely if it raised prior to immigration judge proceedings. A respondent who has made a timely objection to a non-compliant notice to appear is not generally required to show he or she was prejudiced by missing time and date. Not required to show that prejudice. It's Fernandez, Your Honor, says that here. On top of that, inconsistencies, details were overlapping. MS-13 called, arena members called, multiple events were there, were not inconsistent, were connected together to say that she was threatened to cut her throat, her daughter, to kill her daughter. So the threat was there, severe threat. It was not inconsistent. Multiple different events happened. And affidavit and the asylum hearing did not even talk about anything about other things. They said the same things: 2 threatening calls, extortion threats, and political threats. So asylum application with the affidavit on it says reference to the same extortion threat.
The asylum application did not check the box for political opinion, though.
When, Your Honor, am I allowed to?
You can answer the question.
Yes. So asylum application did not show, but the testimony, the record is complete after the application, affidavit, and testimony.
Well, the asylum application says at the last page, signed and sworn to before me by the above-named applicant. So that was a sworn, that's another sworn statement, and it didn't list political opinion.
Included with the affidavit and testimony is a complete record, Your Honor. Application, affidavit
I
in the
understand
application, and
your argument.
testimony.
You got it.
Thank you, Your Honor.
Very good. Thank you very much. And Ms. Lee, we thank you. We'll take this case under advisement. And we're going to come down and greet the counsel that's here. And then we're going to return to the bench and we're going to have a conversation with the high school students that are here.